Welcome to the McCarthy Report, the podcast where I, Rich Lowry, discuss with Andy McCarthy the latest legal and national security issues. This week, what else? The latest on the Mar-a-Lago search yet again. You are, of course, listening to a National Youth podcast. If for some reason you're not already following us on a streaming service, you can find us everywhere from Spotify to iTunes. And please give this podcast and Andy McCarthy the glowing, indeed gushing, 5-star reviews they deserve on iTunes. And now, without further ado, I welcome to this very podcast, through the miracle of Zoom, none other than Andy McCarthy.
Rich, how are you?
Good, Andy. How are you?
I'm good. I had a flash this morning, which actually depressed me a little bit. I took my younger son, who's not so young anymore, to the Met game the other night. It was great. You know, DeGrom pitched. Nimmo saved the game with a great catch in the outfield. It's the first time I'd been at Citi Field in eons. I had forgotten how nice a field it is. It was a great night. But do you have on your phone, do you have this program? I never subscribe to this, but I think it's just like a feature of Apple stuff. So every morning, like there's new pictures that are flashed up on the screen. Mm-hmm. I guess it goes through all your pictures that you have, and it gives you
groups them by theme.
What's that?
Groups them by theme, you know.
Yeah, exactly.
Baseball parks or
yeah. So what flashed up this morning was this picture of myself and my son at Mets spring training in Florida, like probably 8 or 9 years ago. Mm-hmm. And I noticed when I saw it that I had the same, my old school Mets cap. I was wearing the same cap that I wore to the game the other night. So I got the picture up from the game the other night and I got the picture from spring training. And what I noticed was my son, who I was about a foot or more taller than when we took the first picture, is now taller than I am. And he looks great. And the hat looks great, but I look like I've gotten about a million years. So I don't know what you're doing to me here, boss, but I've been done.
It's the work. I mean, you write a piece every single day. Of course, you need to take care of yourself, Andy.
Oh, I guess. Well, that's the crazy. Well, we need to take care of the country because I think it's aging worse than I am at the moment, and that's saying something.
So let's briefly hit on the speech last night. We're recording late Friday morning here, as is our wont, and Biden gave his dark Brandon speech last night before an Independence Hall that has never looked more ghastly or threatening, and a speech about the threat to the soul of America represented by MAGA Republicans. And I think we have a similar political interpretation of this. My take is that he wants to elevate Trump. He wants to troll Trump. The more indefensible things are that Biden says, or at least the more controversial they are, semi-fascist, all that, the better for the White House's political purposes, because it stirs the pot on Trump.
Yeah, I think that's right. I think the Democrats have a good plan. I really think the plan is along the lines of what you're saying. They want to goad Trump into running, which is not going to take much goading. But the key here is they have to animate his base to the point where they bring around reluctant Republicans to back him, which the investigations, I think, have that effect. You know, when they did the search, remember, I think we talked about this last week, but when they did the search at Mar-a-Lago, there were people who came out and said that this guy now has to be nominated by acclamation. Mm-hmm. So they're hoping, I mean, look, ever since Trump has been front and center for the last 3 or 4 weeks, Biden's numbers are up. It's not, I wouldn't call it a surge, but they're, mm-hmm. He's in better shape. The midterms don't look as bad at the moment for the Democrats as they did about a month ago. They don't look good, but things have improved for them. And making it all Trump all the time has people's attention off some pretty atrocious things that the Biden administration has done in just the last few weeks. And even I think most people even miss the 1 year anniversary of the Afghanistan atrocious pullout. So it's working for them, and I think the plan is they want to goad him into running. Well, I am baffled every time I talk to people on our side who say they're trying to get him sidelined or disqualified or thwart him from running.
Yeah,
they're poking him, but they want him to run, and they want to make sure that they outrage his supporters enough that it becomes like a point of honor that you have to nominate him at this point. And then they figure they're just going to friggin' kill him when the November election comes around, because he can't win a national election. You know, I think he won a national election in 2016 against a historically bad candidate when it was a statistical miracle. He pulled an inside straight every place that he was within the margin of error, but behind. Everything had to go right for him to win, and he still won only by the skin of his teeth. And that was his high watermark, really. And now if he tried to run again, it would be unlikely enough to win, not as the incumbent. I mean, he had a lot of advantages in 2020, even though he was the underdog. But now he'd have to run not only with the Capitol riot around his neck, but everything else that we're now dealing with, which are pretty serious criminal investigations. So I think he'd get I think the unfortunate thing, Rich, is what Biden calls the MAGA Republicans. And, you know, I mean, we can quibble about who they are and, you know, and how much of that Biden is, you know, turning into a libel and all that stuff. But I think the problem is the MAGA Republicans, the real MAGA Republicans, are so devoted to Trump, and they see him as not only, you know, someone who achieves so much, but has so much potential to achieve more, and as the instrument by which they fight the left, that they can't internalize the fact that he is very unpopular nationwide. And that if he ran as the Republican candidate, he would probably lose by 15 points. I know the polls say what they say now, but if it got down to brass tacks, he'd have a big problem. And now he's got a bigger problem because, you know, he's got some pretty serious criminal liability hanging over him that they can pull the trigger on whenever they want, whenever they think it's expedient for them.
All right, so a good segue there, Andy. So just one last point on what you're saying about the speech and the politics. So I tweeted the view I just stated a minute ago on Twitter, and some guy at the Atlantic had a theory that was great politics, and used my tweet as evidence of it. And one thing he was saying is that this is brilliant of Biden because he's dividing the Republicans. And I was like, no. He's uniting the Republicans behind Trump. That's the subtlety you're missing. Yep. But so you last week or so, you've changed your view on where the Mar-a-Lago thing had been headed. You had been above 50% on a January 6th indictment, eventually coming down now on the McCarthy doomsday clock on an indictment related to Mar-a-Lago, and specifically an allegation of obstruction has ticked to, you know, you're 5 minutes away from midnight now on that. So explain, go broad gauge what you're thinking, where we are now, and then we'll dig in as we always do on various threads.
Well, Rich, I just want to point out that I'm a professionally trained weasel. So I've heard a number of times in the last couple of days that I've changed my position on Mar-a-Lago. I always had a caveat in my position on Mar-a-Lago, which was they said in the warrant that we got to see and everything else we had gotten to hear, they said that there was probable cause to believe there was evidence of obstruction of justice. And what I've tried to point out, even in writing about this, is I don't think the government wants to do a classified information case on Trump, because classified information cases in the best of circumstances are very difficult. And I don't think they want to do a records retention case, because that would be a bizarre case to bring in the first prosecution against a former president, especially since, as originally enacted, the Presidential Records Act didn't have any criminal law provisions to enforce it. But I thought that the most important sentence in the redacted affidavit that was released, or the portions that we got to see, was the one that said there is probable cause to believe that evidence of obstruction of justice will be found at Mar-a-Lago. And we didn't know, because they never told us, and everything was covered up in the warrant affidavit, what their evidence was. And we kind of knew what the classified evidence was, more or less. We kind of knew what the central allegation was with respect to records retention, but we didn't know what all the obstruction evidence is. Tuesday of this week, in the very late evening, the Justice Department filed their response to Trump's motion for a special master that we'll talk about. And for the first time, they laid out in detail what their obstruction evidence is, and it's pretty damning. It would be a very tough case. You have what looks like a very black and white false statement. That's a sworn statement under oath that was intended to be for the grand jury. You have other statements that prove to be untrue that are made to the FBI agents and the Justice Department lawyer who met with the Trump people on June 3rd. So, it looks to me like they have a pretty strong, anytime you have strong evidence of lies provided to a grand jury during an investigation. We've talked a lot of times, Rich, about false statements to FBI agents, and there can be a lot of debate about that and a lot of argument about it because they're not transcripts. They're not like, they're the agent's recollection. And, we've discussed all the potential weaknesses of those kinds of cases. On the other hand, if you have somebody's actual statement that's made under oath that the person writes and signs, and in this instance, we're talking about a statement from a lawyer who was an agent of Donald Trump. So it would be, as a matter of law, it's as if it were his own statement. And in fact, there's reason to believe that he knows a lot more of the background details than the lawyer who signed the statement may have known. Whenever you have evidence like that, that's a pretty good start for not only an obstruction case, but a perjury case and a false statements case. So, I think they're in trouble.
Mm-hmm. So let's walk through it here. So we got 15 boxes, which we know in January 2022. We have the letter from the archivist saying, we're going to disclose these boxes to the FBI. Then you have the subpoena in May. Then you have the early June meeting. Let's pause there and get into that, because the filing we got from DOJ provides more information about that, correct? And basically rebuts the idea. The impression we've had from Trump and his guys is cordial meeting. Trump, who's ever the good host, shows up. You guys want to Diet Coke, whatever you want, we'll get you. And it's a warm meeting. They give them some stuff that they want, and then it seems that everything's hunky dory. And then boom, all of a sudden, a couple months later, you get the search. But the DOJ's portrayal of what was happening there is different.
Yes, it's very different. I mean, to begin with, the meeting is under duress. This is not a cordial negotiation. The cause of the meeting is a grand jury subpoena, which means there's a criminal investigation. And they know it's a grand jury subpoena because the government's investigating mishandling of classified information. So the president or the former president is the subject of a criminal investigation. That's the circumstances under which it happens. And why does it happen in Mar-a-Lago, Rich? Because it's a case that involves classified, heavily classified information. So in an ordinary case, when you give someone a grand jury subpoena, the idea is they show up to the grand jury to testify. But obviously, they don't want people tootling up to Washington from Florida with heavily classified information. So the conditions of this particular subpoena, which is issued on May 11th, are the FBI. You don't have to bring the documents. The FBI will pick them up on site. And presumably what that meant was Mar-a-Lago, which is where they believe the documents were. So just contact the FBI and they will pick it up on site. But in lieu of a grand jury subpoena, a grand jury appearance, you need to provide a sworn statement, because this is what, if you were called to the grand jury, you'd have to testify in the grand jury under oath, right? So what they say is you need to provide a written sworn statement that this is all the classified information that there is after a thoroughgoing search has occurred. So those are the conditions for the meeting. And it looks when they issued the subpoena, there was at least ostensibly there was a pretty serious attempt to pull together what the lawyers may have believed was all of the conceivable classified information that was on site at the time, because the Trump team, the subpoena is originally returnable on May 24th. The Trump team asked for an extension. So you would think that they were trying to pull things together and they're being careful about it. The Justice Department offers them an extension until June 9th. And while they're waiting to hear back, all of a sudden they get a call on June 2nd, the Justice Department does, from the Trump team. And they say, the stuff is ready. Why don't you have the FBI come tomorrow and pick it up? So that is the occasion for this contingent of 3 FBI agents and Jay Bratt, who is the lead prosecutor in the investigation. He's a high-ranking lawyer at the Justice Department's National Security Division. I think he runs the counterintelligence and foreign export section, or export control section. So anyway, Bratt and the 3 agents go to Mar-a-Lago. Now, interestingly, Rich, in the government's papers, they don't mention that Trump showed up at the meeting. The government's summary of what happened is completely about their interaction with the 2 Trump lawyers, who are not identified by name in the papers, but who we know to be Christina Bobb and Evan Corcoran. And that's on the basis not only of reporting. I think Christina Bobb's made public statements about what happened. And so what they talk about in the government's papers is their interaction with the lawyers. When they get there, now, Rich, this is very important because remember, Trump has been making statements about whether he declassified the documents or not. And a big to-do from the Trump camp is that everything's declassified. So it's very important what happened here. They got a subpoena commanding that they surrender any classified documents that were in the former president's possession. The Trump camp didn't come back and say, we don't have any classified documents because they've all been declassified. Instead, they said, come and get them. And when they get there, the 2 lawyers give the Justice Department team, or this contingent of government officials, a red-weld envelope that is double sealed. The government in their papers makes a point of saying that they seal wrapped it twice to underscore that this is like heavy duty. They understood this was like the top secret information.
So
and the red-weld,
there's significance to that kind of envelope. I'm not an envelope expert.
Oh no, I think that's just a style of envelope that can hold files and that kind of stuff.
Oh, does that have the little red dot and the little string?
Yeah, it's a little bit different from that, but it's the same idea.
Okay.
So anyhow, they give him this double wrapped red weld folder or envelope that has 38 classified documents in it. And they also turn over a sworn statement that is executed, the reporting says, by Christina Bobb, although she says that it was Evan Corcoran who ran or who oversaw the process of identifying and turning over the classified documents. I think, Rich, that Christina Bobb is in the position of being the custodian of records for Trump, and Corcoran is a lawyer, and he's still a lawyer on the team. So I think the reason why she signs is because the subpoena is not to Donald Trump. The subpoena is to the custodian of records for the Trump post presidency.
I don't know anything about Christina Bobb, but what did she do to deserve being custodian of records for Donald Trump?
These are all volunteers, Rich. What am I going to tell you? So anyhow, they turn this over. And then the next thing that happens in this nice, friendly, cordial, completely cooperative and transparent meeting is the FBI says to the Trump lawyers, where are you storing these government records? Because we'd really like to get a look at that. So they say, oh, yeah, it's in a storage area here at Mar-a-Lago. So they take the agents and Bratt to the storage area where they have several boxes of what they say are records. So the FBI at this very cordial cooperative meeting says to them, can we look inside the boxes so we can make sure for ourselves that there's no more stuff in there? And they say, no, you don't get to look in the boxes. So they wouldn't let already, everybody's antennas are pinging because they wouldn't let them inspect. And to your point about how the Justice Department's position is that the meeting's been misrepresented, another thing we keep hearing is that the Trump team is basically saying the government said that as long as you put a stronger lock on the storage area, it'll be fine. You don't have to worry about, right. We're good. And the government's position was not that at all, according to the government. What they say is those are our records. They're not his records. We were not ready to escalate on June 3rd to the point of having the agents physically just grab the boxes and take them away. And I must say, Rich, to my mind, I think it might have been better here if right there and then Brad had given the Trump lawyers a forthwith grand jury subpoena and told them turn over the boxes to the agents, because then they could have made a record that we asked for this stuff by court process and they still wouldn't give it to us, which would have, in my mind.
What is a forthwith grand jury?
All grand jury subpoenas say, you are commanded to appear such and such a day, at such and such a time before the grand jury. But in exigent circumstances, you can give somebody a forthwith grand jury subpoena, which basically says now you must comply. And they can run into court and try to get it quashed. But it would have escalated things, but it wouldn't have escalated it to the point of doing a search warrant. And I think the Justice Department could then have made a better record that they tried everything they could short of getting a search warrant to rummage through.
So just to pause right there. So just to review. So the grand jury subpoena was for all classified documents.
Correct.
They show up and they say, here are the classified documents. Congratulations, they're in this envelope. And then the FBI says, what about those boxes?
Well, they also know that, the other thing that thrums under all of this is that there's this other issue about the presidential records. And remember, the way the FBI gets involved in this in the first place is that NARA is trying to get their records back, like all the records, not just the classified stuff. Okay. And the way the FBI and the Justice Department get involved is that when Trump gives this first 15 boxes, they find classified information in it. So this is all kind of bundled together. And the other thing, Rich, I should point out, since you bring this up and it's relevant now, so we might as well deal with it. The Justice Department's filing the other night does confirm what we've suspected in our discussions about this the last 2 weeks, which is that the Justice Department has taken the position that even though the Presidential Records Act didn't have criminal law provisions when it was enacted, this statute in the penal law that they're relying on, 2071, they are stitching that together with the Presidential Records Act. And now basically they're saying that statute says that you can't remove or conceal government files. Presidential records are government files. They're ours, and this is a criminal law provision that we can enforce the Presidential Records Act with. So they are definitely taking that position. So the government's position here, essentially, Rich, is that they're putting their marker down. All of the records are ours. They don't belong to Donald Trump. They belong to the United States government. But the emergency right now is the classified information. We want the classified information, and then we'll deal with the rest of it. But we have to have the classified information. So that's where they're at. And what the Justice Department says is, we made it clear to them that those are our records, and we're not happy with the security situation. But basically, they said, we're going to deal with this, but we're not dealing with it today. Today's about classified information. And what President Trump apparently took that to mean is, we'll just put another lock on. So he had them improve the security there. But what he is saying publicly is that this is what the Justice Department asked him to do. Mm-hmm. And what they're saying is, no. What we told them was we were very unhappy with the security situation there. And they took that to mean if we put another lock on it, things will be peachy. And that was not what we meant by that. So that's the disconnect there.
So Bob signs a sworn statement. Is that sort of on the spot, or she has it ready to go for the FBI? Here are your 38 classified documents, nice in this secure envelope. And there's nothing else. Here's my statement saying there's nothing else.
Yeah. My understanding, Rich, is that was prepared before the government contingent.
Yeah.
Because it's responsive to the grand jury subpoena.
Okay.
In other words, if they hadn't provided that wouldn't have been compliance with the subpoena, because what the government wanted was what they would have gotten if she had actually shown up at the grand jury and testified, which is they would have put her under oath and asked those questions. Yeah. So instead, she puts it affirmatively in a statement.
So the problem is this isn't true, right? So
that is a problem. Yep.
So and it's intended for a grand jury, which isn't good. Is there any defense? Well, she didn't know. They thought they're still disorganized. So they thought their search produced these 38 classified documents and there was nothing else. So okay, our bad. We gave you the statement that wasn't technically true, but we haven't intentionally deceived.
Yeah, I think, Rich, that probably what the lawyers will ultimately end up saying, if there are charges that flow from this, is that there was a failure to communicate. Mm-hmm. So, everybody knew what the government wanted, but, Christina Bobb is the one who signs the statement. Evan Corcoran is the one who runs the what they call the diligent search that was done through the boxes. They are led to believe, according to what they would have you believe, that they believed all the classified information was in those boxes. It's unclear that they undertook to look anyplace else at Mar-a-Lago, including President Trump's office. And I assume President Trump would say, look, I don't know. They're my lawyers. I told them figure it out. So, I have a feeling your defense here, to the extent you would have one, would be, we just didn't communicate well. We didn't mean to mislead anyone, but we thought everything was in the boxes. And Trump will say, well, I didn't get involved in what they were doing. I didn't even read their statement before they gave it, which, by the way, I mentioned before that the Justice Department doesn't talk about Trump being at the meeting, which I think is interesting. But the fact that Trump did pop in at the meeting does not help him distance himself from, the negotiations between the lawyers and the FBI guys. So I do wonder whether that has anything to do with why the government didn't address that. It's like one of those things that's a really weird thing, because Trump has been out there saying so much about how he even popped in himself at the meeting. We had this friendly conversation, and they stress that in their own papers, and the government just lets it go and doesn't say anything. That I think is curious.
So there are also other statements in this sworn statement that aren't right, and that could be.
Well, Rich, it's a combination of the sworn statement, which is what's supposed to be produced to the grand jury, and then remember they're having a meeting with FBI agents. So in addition to the fact that they're delivering the sworn statement, they're also discussing the situation, right? And one of the things they tell them is, we've gone through these boxes very carefully that we're not going to let you look inside of, and this is all there is. So that becomes important because when they do the search on August 8th, the FBI goes through those boxes and they find, I think it was 76, maybe it was 96, it's 76 at least classified documents. So the government, the Justice Department in their submission the other night makes a point of saying that in just the few hours the FBI was there, it found twice as many classified documents in those boxes than the lawyers found in all the months that they had to assemble this stuff.
So speak to this photo that became a big issue online, and Trump also addressed it. It was kind of an evidence photo. I don't know what the technical term for it is. Sort of thing, you find pull over a U-Haul truck as part of a drug investigation, and you pull out all these drugs and submachine guns and whatnot, and you lay them out and take a photo, and it's on the front page of the paper the next day. It's sort of that kind of thing, but it's documents clearly that you could not have missed if you looked through a box. You would have seen these things are marked clear as day that they're classified, and so they're sort of set out on the rug and a piece of paper put over the top of the front page to avoid any identifying information. And a lot of critics saying, well, "Come on, why is the DOJ playing this PR game?" They're sort of, it's being misinterpreted as Trump had them out like this, when of course they would have been in boxes. What do you make of the photo controversy?
Well, first of all, the government should never do that. This business where they get seizures when they do search warrants and then they splay everything out on a table, like the drugs and the guns and the money and all that stuff. At that point in time, no one's been charged yet often. None of that information is public. Now, sometimes what I used to do in these cases where they were going to do that was I would put the stuff that was seized in the complaint when we arrested someone, so that at least I would be able to say that we didn't put anything out that wasn't public record information. But in the Trump situation, no one's been charged with a crime. So, when the government puts out stuff that's been seized in a search warrant under circumstances where no one's been charged, that's only to influence the jury pool and shape public opinion. There's no good reason to do it. Now, let me be clear about this. When you send agents to do a search warrant, you encourage them to take pictures. I always encourage them to take pictures because, for example, let's take the Blind Shay case. I arrested people in June of 1993. A lot of those agents didn't testify until June of 1995. So the photographs during the search helped the agents refresh their recollection about what the place looked like, where they got stuff, and the stuff that they have to testify about in front of the jury. So you encourage them to take pictures because it's an aid to their testimony. But this is not supposed to be a demonstrative public relations exercise. Moreover, this submission by the government is to a district judge to explain why there shouldn't be a special master. Do they think that unless they give a picture to Judge Cannon, that she's not going to understand their papers? So the only reason that I can see rationally to do this was to make Trump look bad, because they knew that some people were going to look at that picture. And even though the government has all the caveats where they say, no, this is not the way it appeared, this is like, we just laid this out, people don't read that stuff. They look at the picture. So in the public mind, this is what Trump's place looked like. He's being investigated for carelessly mishandling classified information. And they put a photograph in the public thing they find that has classified information splayed all over the floor.
Right. Yeah.
So it's really, if you think about it that way, it's outrageous, and they shouldn't do it. And Trump was, if I'm the defense lawyer, I'm telling Trump, please be quiet. Please don't say anything. But if he was going to say anything, I could understand him being critical of the FBI. The problem is, as always with Trump, he brings out the worst in his opposition. The FBI shouldn't do this stuff. And I don't know what the adult supervision, you would think that they sent their best agents to do this. This is like the top classified information, and they're doing a historic search warrant on the home of a former president. You would think that they didn't send the clown car for this, right? This has got to be their top guys. So whoever thought this was a good idea, I don't know. But apparently Brat didn't have any problem with it because he included it in his submission, which, by the way, I point out, the government's papers are very well done. The legal argument is exceptionally good. Why they would think that they needed to put this in there, I don't know. They shouldn't do it. But, of course, Trump always has to go them one better. So he not only criticizes the FBI for splaying everything out, he then says in the post that he put out, as they know, I had those in cartons in my office. And the thing is, last week he was saying they planted it. You know what? So 1 week it's like he didn't have it, and then he had it, but it was declassified. And then, it was there's no document that it was declassified, but he imagined it into declassified status. And then they planted it, and now I had them in cartons in my office, and they poured them all over the floor. So, I think he doesn't grasp that everything he says it can be used against him in court. And when this is not a clown show anymore. He's like in real legal jeopardy. And I presume his lawyers are telling him, look, you're not controllable. You're going to do what you're going to do, but understand everything you say, they're going to use.
Yeah. So just last thing on this, Andy, before we get to January, the state of the January 6th investigations, and then wrap up. So you mentioned the special master. So what's going on there? What is a special master? Why does Trump want one?
Well, the special master, Rich, is something he should have asked for. I mean, this was a 9 or 10 hour search warrant. They should have had a lawyer in court screaming for a special master while the search was going on. A special master in this instance, there's a variety of reasons why you might have a special master, but in the context of a search where you're worried about privileged information, a special master would be a designee or an appointee of the court who would oversee the process of making sure that the lawyers and agents who are doing the investigation do not get to see the privileged documents, if they're attorney-client privileged or any other privilege that might apply. What happens in these situations is, and you can tell this, I think we talked a week or so ago, one of the last couple of episodes, I mentioned that the Justice Department would have put in their search warrant because this was a situation where it was obvious that there was going to be privileged information. They would have put in the search warrant that they were going to have their filter process or their privilege process. And what that involves is, you take 2 or 3 lawyers, depends on how much stuff you think you're going to find, 2 or 3 prosecutors who are not involved in the investigation, whose only job is to go through everything that's been seized to eyeball and identify what might be privileged, and keep that segregated and don't let the prosecutors who are on the case see it. So like in a normal search, you send the agents out. If there's no privilege issues, the prosecutors on the case get to see the seized evidence right away. In a case where there's privilege, somebody has to go through it first to make sure they don't get to see attorney-client privilege stuff, because if privileged information is used in the development of evidence, it can result in counts getting dismissed. If lawyers get exposed to, say, attorney-client privilege information where the defendant or the suspect and the lawyer talk about their legal strategy, the prosecutor can be disqualified from being on the case because he's been exposed to the defense strategy. So they have to be very careful about this. And actually, when Trump moved for this, even though he did it belatedly, what I tried to point out is that this is not just for Trump's protection. This actually is for the protection of the prosecution. I mean, not that Trump cares about that, but the government should care about that. The reason you go through this process and the reason the government proposed it to the magistrate judge in the first place is because they have to demonstrate that they're being careful to make sure that they're respecting privilege and the prosecutors are not getting access to it. So if you're the suspect, Rich, you don't want the government to do this unilaterally, right? What the Justice Department is always happy to do is say, don't worry about the privilege thing. We'll take care of it. We have this swell team of prosecutors who are going to go through it, and they'll decide what the other prosecutors get to see. Obviously, most defendants don't want that. They want their lawyers involved in this thing. And short of that, what they want is it to be supervised by the court not done by the government. So what Trump asked for was, this is basically a referee who would come in on behalf of the court and review the government's process of making sure that the privileged information doesn't get to the prosecution team. So that's what this was all about. The problem here is that Trump waited 2 weeks to move for it. So in the meantime, the government, when they got the warrant, told Magistrate Judge Reinhardt, this is the process we're going to use. And Reinhardt signed off on that. So without any special master in place, without any court telling them there needs to be a special master, without Trump moving for a special master, the government did exactly what the magistrate allowed them to do, which was they implemented their own procedure. Then when Trump finally got around to moving for it, he asked, by then, there's a little procedural quirk here. He tries to get this in front of a district judge rather than Reinhardt because he thinks Reinhardt is biased against him. So he, instead of what you would normally do in this situation, if you had a complaint, was you would go to the judge who signed the warrant. Trump doesn't want to go to the judge who signed the warrant. So he files a separate civil lawsuit to try to get this in front of another judge, which he does. Aileen Cannon, I'm sure she's thrilled, but she ends up catching this case. She's a Trump-appointed judge. She was appointed by Trump in 2020. That doesn't mean Trump could pick her out of a lineup. She's probably much better known to like Marco Rubio and Scott down in Florida than she is to anyone who was in the Trump White House. But anyway, she's a Trump appointee, and she catches this case. She's not happy about catching the case. It's clear. And they're all wondering aloud, like, why did you do it this way? Why didn't you just file a motion in front of the magistrate? But be that as it may, the government's argument is basically this is moot because he waited so long to move for a special master. By the time this got in front of Judge Cannon, they had already almost finished their process. Now, where I think the government plays it fast and loose here is this litigation all happened last week and weekend. And it was on Saturday of last weekend, Rich, that Cannon said she was inclined to grant a special master, but she hadn't made up her mind yet. She wanted the government to respond to Trump's papers by Tuesday, which is the filing we've been talking about. And then she wanted to have a hearing on Thursday, which was yesterday. And they did have the hearing. So I think if you're on the up and up as the prosecutor there, you really owe it to the judge to say, look, Trump is asking that you suspend our review. Are you telling us to suspend the review? Is the fact that you're telling us to respond and you're having a hearing, are you telling us that? Instead, she didn't rule on that application, and the government went ahead with its process, which was, I thought, a little sneaky on their part. I think in where I came from, in our court, they would have expected the prosecutor to flag that for the judge. So in any event, they didn't. So Monday, the day before the government's papers were due, they sent her a note that says basically, we're done. So, of course, the question then becomes, what's the point of having a special master if they've already done their process, they've reviewed what they think is privileged, and they've given everything else to the prosecutors and the FBI agents on the case? And just to put a point on it, that what we're waiting on now, Rich, they had this hearing yesterday. She still hasn't decided whether she's going to give him the special master. But here's the issue, and it could be explosive, although I think the government will win. The government took the position that the only privilege Trump had was attorney-client privilege. Trump is claiming that he has executive privilege and attorney-client privilege. If he's got executive privilege, that would cover almost everything. I mean, it would cover mounds of the stuff that they seized. They assumed that he didn't have that. So their position legally, which I think is justifiable, but this is why you want to get a court ruling before you start doing things rather than after. Their position is executive privilege, to the extent a former president may have it, cannot be asserted against the executive branch itself in a way that prevents the government from carrying out its core responsibilities. Like, what they're basically saying is, look, maybe you can assert it against Congress. Maybe you can assert it against, to avoid testifying in a trial. But that you can't assert executive privilege against the executive. And they base that in part on the Supreme Court case, Nixon versus administrator, that recognized this idea that former presidents have some quantum of executive privilege. Because in that case, even though the Supreme Court said former presidents have some executive privilege, they also didn't let Nixon assert it against the General Services Administration, because the court said those are executive officials who are mindful of executive concerns. So we're not going to let a president assert it. If Nixon couldn't assert it against the GSA, you would think that Trump can't assert it under circumstances where the intelligence community needs this information so that they can figure out whether our national security has been damaged. So I think the government has a very strong position, but I'll just repeat what I said last week, Rich, was I think they're playing with fire here because they didn't need to do it this way. This is hyper aggressive. They could have gone in, they could have said to a judge what I just said to you in a minute and convinced the judge, yeah, he doesn't have executive privilege, and let the judge sign off on it and then do your process. So now, when this got argued yesterday in court, the government lawyer said, a special master has nothing to say about executive privilege. And Judge Cannon said, I'm not so sure it's that cut and dried. So we don't know how she's going to come out, but if she were to suddenly rule that, it turns out that Trump had executive privilege and you shouldn't have shown the executive privilege documents to the team that's doing the prosecution or the investigation, that's going to be a very big problem. My prediction is 9 chances in 10 it doesn't happen, but Judge Cannon has seemed so reluctant about this whole thing, and there's a lot of hand-wringing going on. She doesn't like having the case in front of her, and it seemed to me that yesterday she wants to give Trump something, but it's too late to give him what he really wanted. And her basic point was, even when the government made all its arguments, what she said was, what's the harm? What's the harm of having a special master? And that's not a good position to make a legal argument from. You don't do something that's wrong because it doesn't seem like it would be harmful, So we'll have to see what she rules. It could happen today, maybe next week. We'll see.
Okay, so let's hit some January 6th things. This has been in the news cycle relatively back burner compared to Mar-a-Lago, but these investigations are progressing. So we get Pat Cipollone and Pat Philbin scheduled to testify actually today, Friday, before the grand jury in Washington. There have already been 5 others we know about.
Yeah, I was talking to some friends who cover stuff in Washington, and I understand Pat, when we started our podcast, Rich, at like 11:30 or whatever time we started, Pat Cipollone was in the grand jury and had been in for I think a couple of hours. And no one's seen Philbin yet, but the reporting is that he's supposed to testify today as well. So it's just to remind people, this is like, it sounds like you just said it's back burner. 2 weeks ago it was front burner with a bullet. Right now it's back burner. But they have put 5 high-ranking White House officials now in the grand jury, and it's a serious investigation.
And the January 6th committee, we have a subpoena of Newt, and we have a lawsuit from Mastriano, the very stop the steal-ish gubernatorial candidate in Pennsylvania.
Right. So Newt has been subpoenaed, and they have sent him a letter basically saying, look, you were involved in all of this planning with respect to approaching state officials to try to get them to set aside the popular election and throw the election into the state legislatures that were controlled by Republicans. I have to say, Rich, and I'll say this about this as well as the next thing we're going to talk about, which is Fulton County, that other investigation. This, again, is criminalizing a legal theory. I mean, basically, they were saying that, they had this legal theory by which you could set aside the election results and try to throw the election back into the legislature. It wasn't a good theory. They didn't have strong evidence of it, but to say it's a crime is I think that's really is really pushing it. And that's what they want to talk to him about. So they're asking Newt to come in and testify. Whether he hasn't made a comment on this yet, so or at least he hadn't when we sat down. So I don't know where that's going to go. Mastriano, you can understand where he's coming from because he's obviously running for office, and his objection, he's already walked out once when he agreed to sit down for an interview with the committee. But he didn't like their videotape process. And it's no wonder that he didn't, because as we've discussed in these high profile hearings they snip through the video and they put in what they want. And he realizes like he's running for office and they're going to, slice and dice the video and make him look bad. And then that becomes, campaign fodder against him. So now the other thing, they've now subpoenaed him. The first session, I think, was a voluntary sit down, which he then decided he wasn't going to be a volunteer anymore. This is now pursuant to a subpoena, and he now is in court fighting the subpoena because the House rules say that a subpoena's got to be signed off on by the chairman of a committee and the ranking member. And the argument is the January 6th committee does not have a ranking member. And that may be, it has a co-chair in Liz Cheney, but she's technically, the argument is, not a ranking member, and there's a good chance he could win that.
So you mentioned Atlanta. That's also cooking along. You have Eastman, who testified and took the fifth. His lawyer believes he's a target of that investigation, and continued contention over Lindsey Graham and a subpoena of him on the theory that he might have been extorting Brad Raffensperger, the Secretary of State.
Yeah, well, on the Eastman thing, Rich, this goes to a point that you actually raised a couple of weeks ago, which is when we were talking about the Atlanta thing. That's been a very interesting investigation, and one of the things that we mentioned that had happened was that these guys who were cast as fake electors or phony electors, they were initially told they were just witnesses, and then all of a sudden they were told they were targets. So right. I think what Eastman's lawyer is saying is, look, they haven't told him he's a target, but he's a target, because even when they tell people that they're just witnesses, they turn out to be targets. And they think this is just a very political investigation. And again, Eastman is under investigation for a legal theory. With respect to Lindsey Graham, they've subpoenaed him just like they subpoenaed Eastman and Rudy and a bunch of other people to testify in their grand jury. Graham has been fighting the subpoena. He had the misfortune for him of landing as the judge in his challenge, a woman by the name of Lee Martin May, who was an Obama appointee who was pretty adamant that he should testify. So what's happened, this has become like ping pong. She initially said he had to testify. Then Lindsey appealed to the 11th Circuit. They sent it back to Judge May to tell her, think about the speech and debate clause. She just ruled, I think it was yesterday, maybe the day before, that she's thought about the speech and debate clause, and that may narrow what they can ask him, but he still has to appear. So now he's back to the 11th Circuit. But I would just in a conclusory way, what I would say, Rich, this investigation that they're running in Atlanta, in Fulton County, basically what they're saying is you have a Democrat who won an election, and you have a bunch of Republicans who are trying to come up with a legal theory to undo the election, and that's a racketeering offense. Remember, in connection with the Atlanta case, it's like the Capitol riot never happened. The Capitol riot has nothing to do with Atlanta. Atlanta is just about, did they try to get the election overturned? And what they're trying to do is turn the fact that they made legal claims and that they tried to put political pressure on the state legislature. They're trying to turn that into a racketeering conspiracy, and that's their theory. So I think it's worth watching. We'll watch it.
So just last thing, this episode, Andy. So obviously you've been skeptical. You just stated it. state the reasons why of January 6th related prosecutions based on what we know now. But going back to Mar-a-Lago is an obstruction case a different animal? You know, that's the kind of thing that's prosecuted all the time. There seems as though there could be solid evidence of it. You have maybe less of a problem with inconsistency. You know, if you're going to try to do mishandling classified documents, if you gave Hillary Clinton a pass several years before.
Well, I mean, I think they gave Hillary a pass on some obstructive behavior as well. I mean, remember, she tells the FBI in her interview that she didn't know what the classified markings meant, right? You know, like C, she didn't know what C meant. Right. Someone who's been like a consumer of classified information for 20 years at that point didn't know what the markings meant. So, but it obviously that was not as black and white as this is. I think the problem, Rich, which you're hitting on here, is this is kind of more along the lines of what Bill Barr calls a meat and potatoes crime, right? Everybody knows you can't lie to the grand jury. You know, if you write a sworn statement that's meant for submission to the grand jury, and you tell them this 38 documents is all there is, and it turns out there's another 100 or more, and it's very, you know, high level stuff, and you tell the government that you've done a diligent search and that this is all there is left at Mar-a-Lago, and it turns out that the search wasn't diligent and there was lots more than you represented, I think that's a big problem. So I think, you know, this isn't a hyper technical offense. And the danger, I think, for former President Trump is it's the kind of thing that anyone would be prosecuted for. You know, like the average person knows if you or I go into a grand jury, take the oath, and then lie, we're going to be prosecuted. You know, even when we talk about false statements to the FBI, Rich, a lot of times when we talk about it, we say, now, look, we're not talking about like perjury in the grand jury, right? We're not talking about like somebody went in and took an oath and there was a transcript and they lied. This is what you're talking about with that. So I think, you know, the problem for Trump is this is the kind of behavior that everybody can wrap their brain around. And it's not that hard to prove. You know, it's like one of these things where, you know, you said this and it turned out to be that. Yeah. So I think he's got a problem. It doesn't mean he'll get charged, but I think there's a much greater chance that he'll get charged than there was, that before we knew the facts.
Yeah. Okay. Well, that's all the time we have. This podcast has been produced by the incomparable Sarah Schutte. Thanks everyone for listening, and thank you, Andy McCarthy.
Thanks, Rich.